Lord, may I beg your lordship's leave to mention?
Yes.
Lord, yesterday, your lordship was hearing a civil divisional application, and Lord, your lordship was pleased to stay the impugned proceeding.
Yes.
Lord, that would create a little confusion because the
You are
proceeding.
appearing for the petitioner?
Yes,
Yes.
Lord, the impugned proceeding has been
Yes.
disposed of by the impugned order. So, my Lord, what needs a stay on is the impugned order. That is
So
the.
what was your prayer before the?
My Lord, my prayer was to stay the impugned order. However, my Lord, it was my mistake, my Lord, that I should have pointed out. That small correction needs to be.
Okay, tomorrow, one day to be mentioned.
My Lord, humbly below.
To be mentioned ডেকে দিন আগে। Yes, you are
Yes, Lordship, I only got the appeal and Lordship. Lordship, I am, the matter was disposed of Lordship. But when I apply for the withdraw award Lordship, the stamp reporter is, that shows they did not, they raise objection because the minor children is there Lordship. That mother
minor children means the guardian is to withdraw on behalf of the minor children.
Yes, Lordship. The in Bhogalandama Lordship, kindly see the Bhogalandama Lordship.
Yes.
In Bhogalandama Lordship only petition number 1 and 4 is signature is there Lordship. But minor children on behalf of the mother Lordship.
Minor children is not represented.
Not represented Lordship. Mother is represented, but in the order sheet Lordship, page number 13 Lordship.
Page number 13 of the order of trial court.
No Lordship.
Of this court.
Last order, this court Lordship.
Let me see.
The appellant number 1 being the mother and natural guardian of appellant numbers 2 and 3 shall receive the shares of the said minors and shall keep the same in a fixed deposit scheme of any nationalized bank Lordship and or post office till attachment of the majority of the said
Just let
minors
me see the
Lordship.
order. It was disposed of
It was disposed on
21 to
21 January 2025 Lordship.
21 January. 24 January.
24 January.
Yes, appellant number 1 being the mother and natural guardian of appellant number 2 and 3 shall receive the shares of the said minors and keep the same in a fixed deposit till attainment of majority of the said minors. Now the question is, appellant number 1 is has represented herself,
Yes, Lordship.
but she
As well
has
as,
not
2
represented the appellant number 2 and 3.
Lordship.
That means power is not obtained on behalf of appellant number 2 and 3. That means she has filed power for herself and as well as the.
At the time of filing Lordship, the stamp reporter did not raise objection Lordship. But when I obtained the award Lordship, then they raised objection Lordship. My Lordship kindly give liberty to the petitioner to
File the
another
power.
Lordship.
File power.
Yes,
Yes,
Lordship.
yes, record an order. Learned advocate for the appellant. Appellants are present. As the appellant number 1 has represented herself as well as appellant number 2 and 3 being her minor children. The vocalatnama ought to have been filed on behalf of all the appellants. Stop. As appellant number, as no vocalatnama is filed on behalf of appellant number 2 and 3, represented by the mother, the said vocalatnama may be filed and the awarded amount be released in terms of the order passed by this court on 24/1/2025.
Good. Good.
I'm for the. Already execution process started. Accordingly, there is a limitation of 130 days. Have you filed your application? Section 5, can one?
Yes, can one and can two both are there.
Can one have you sub copy?
Yes, Lord.
Yes, record an order. A learned advocate for the appellant is present. None appears for the respondents in spite of service of notice. Let the affidavit of service file be kept with the record. The application can one of 2025 is taken up for consideration. Our learned advocate for the, actually it is appearing as to be mentioned. That is why whether the order can be passed in absence of the other side.
Actually, Lordship, the urgency, the execution will be.
Okay, record an order.
I have
This application is taken up for consideration. How many days delay?
130 days.
Upon perusing the petition and upon hearing the learned advocates, the court finds that the delay in filing this appeal is furnished and is sufficient. Thus, delay in filing this appeal is condoned. So, can one of 2025 is disposed? Yes, regarding the appeal is also admitted. Yes, can two stay?
Stay.
Have you filed the statutory amount?
Yes, Lord.
Yes, deposit the file that. Yes, this application for stay being can 2 of 2025 is taken up for consideration. As the appellant insurance company has deposited rupees 25, the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 10th day of July 2024, passed by learned additional district judge, second fast track court, Alipurduar, in MSC case number 83 of 2021 for a period of 5 weeks from date. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest as directed by the learned trial court. In the event the deposit is made within 5 weeks, entire amount as awarded by the trial court along with interest, excluding the statutory amount. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this appeal. The disposal of this appeal, the appellants, no, till disposal of this application, the appellants shall take steps to cause further service of notice upon the respondents and file affidavit of service on the reopening date. Let the matter appear before the next available circuit.
My lord, in this matter, my lord has passed this judgment on 16th of December. Here is the copy of the said judgment, my lord. My lord,
Yes.
in page number 4, para number 11, it is not mentioned as to where the insurance company should deposit the rewarded interest amount, whether it should be before the learned tribunal or it should be to the registrar of the circuit bench, Jalpaiguri.
Okay, record an order. Learned advocate for the appellant
Yes, my lord.
is present. The matter is put up for necessary clarification of the judgment and order dated 16/12/2025. Stop. In para 11 of the judgment in para 11 of the judgment of this court, it is directed that the respondent number 1, New India Assurance Company Limited, shall pay 6% per annum on the awarded sum from the date of filing of the claim case till the deposit of the principal sum. But it is not mentioned where the deposit shall be made. Stop. Thus, the respondent number 1, New India Assurance Company Limited, is directed to deposit before the registrar circuit bench, High Court, Calcutta, within the period as directed in the said judgment and order.
And my lord, my name is also being recorded by mistakenly as Mr. S. Bhomik. It should be Miss Srija Bhomik.
Let the name of the learned advocate for the appellant's claimant, which is recorded as Mr. S. Bhomik, be corrected as MS Srija Srija Bhomik.
Grateful, my lord.
Judgment call করে দিন।
Yes, Lordship, I on with the appellant.
Yes. Hence, this appeal stands disposed. The judgment and award dated 21/2/2025, passed by the learned additional district judge, Third Court, Jalpaiguri, in MSC case number 55 of 2022, stands modified to the extent that the appellant's claimants are entitled to compensation of rupees 20 lakh only from the respondent number 1, Bajaj Alliance General Insurance Company Limited. Stop. As rupees 16,54,761 is already paid to the appellant's claimants, the respondent number 1 shall pay rupees 3,46,339 along with interest at the rate of 6% per annum from the date of filing of the claim case till today. Such payment shall be made within 5 weeks from the date of communication of this order.
I am appearing for the appellants.
Yes. It's ready for hearing matter.
Yes. Paper book complete. The issues have been framed.
Yes.
But I have prepared a brief notes of argument. But it may assist my lord.
Yes. So whether you will be able to conclude by today?
My lord,
If not, we'll continue on Monday.
It will take some time.
Anyway, so that another day will be given to you, both of
Yes,
you.
Yes. Your Honor. But I would also like to refer certain judgments.
Very well, I shall consider, yes.
Yes,
please.
I'll prepare the list of judgments and I'll hand it to Your Honor. I couldn't prepare the list of judgments today.
No, whatever you.
I have
You
prepared
just
a brief-
start the matter.
Yes.
This is written notes of argument, very well.
Yes.
You are the defendant appellant.
I am the plaintiff. Well, it has been wrongly mentioned. I am the plaintiff appellant.
Plaintiff. Defendant respondent.
It is wrongly
That
mentioned.
means both the courts went against you.
No. Initially, the learned trial court was in my favor. Subsequently, upon first appeal, the learned first appellate court reversed the order of the learned.
Okay, let us consider. Yes.
But at the outset, if I would refer to the original suit, original title suit, that is original, the title suit number 2 of 1998.
Paper with the thing.
Mala would find the plaintiff of the suit at page number 1 of the paper. Mala takes up page number 1 of the paper. This is the plaintiff which was filed in the original suit, being titled suit number 2 of 1998.
Yes.
My lord would, if my lord has a cursory glance at the post title of the plaintiff, my lord would find that there are in total 7 plaintiffs and 3 defendants.
Yes. Yes, as this matter will take some time, I release the other matters for the day.
My lord, as my lord would.
Yes, other matters are released for the day.
My lord, can we?
Yes, yes.
But would find that there are a list of array of 7 plaintiffs and 3 defendants. Out of those 7 plaintiffs, subsequently the plaintiff numbers 2 to 5, they did not contest they did not carry on with the suit any further. So it was the plaintiff numbers 1, 6, and 7 who carried on with the suit. Since they were not interested to proceed with the suit, there were the plaintiff numbers 2 to 5, they did not proceed with the suit. But the suit was proceeded with by the plaintiff numbers 1, 6, and 7, and accordingly the judgment and decree which was passed by the learned trial court was restricted to only the schedule, only the properties belonging to the plaintiff numbers 1, 6, and 7.
So the the suit with regard to the property of plaintiff number
1, 6, and
1,
7.
6, and 7
Yes.
was decreed.
Yes. Remaining they did not pursue. And in course of the suit, my lord, in course of the suit, the defendant number 1, the suit abated as a defendant number 1 died, and the suit abated as a result, as a consequence, since proper steps were not taken within the time prescribed. The suit abated against the defendant number 1 by virtue of the order of the learned trial court that is dated 9th of April 2015, order number 166.
161. Another paper books. Volume 2 to the.
There's only
161. No, 161.
166. Order number 166.
166, it is not here in this paper.
But there's a trial court record, entire trial court.
No, question is,
166
which page of the paper book?
In page number 1, it is mentioned already in the side note. But takes up page number 1.
Yes, page number 1.
In a side note, it is mentioned against the name of the defendant number 1.
No, you see, it was abated.
Yes.
That abatement was set aside.
That was not so. So the suit continued against the defendant numbers 12.
2 and 3 are the legal heirs of what?
Legal heirs of what? No, not necessary.
So they were already parties.
They were already there with them.
Yes.
So the suit continued. Ultimately, in course of adjudication.
What was the suit for?
Suit for declaration of title and for permanent. Another consequential.
Now, what is the proposition of law on which this appeal is to be heard out?
But two specific issues, but in this case, particularly here, the plaintiffs and the respondents are Kuch Bihari Muslims. And there is one aspect as regards inheritance
What
and
is the
succession.
proposition of law? Let me
My
see.
lord,
But,
Which
sorry,
page?
12th of September 2022, order dated.
But the order that
September.
12th of September.
No, it's not there. It will be part of the order of the, no, it will
No,
be
no, no.
part of the order of the honorable court. The
The
two,
order, yes, what is the order?
Well,
Just you have
take
the copy of the order? Give me-
Malad, takes up page number 150 of the paper book.
Okay,
It's already
150.
there in the paper.
Yes, admission order.
Page number 150 of the paper.
Yes, whether the plaintiffs and defendants were governed by the Mohammedan law of inheritance or Daibhagas
Of Hindu law.
of Hindu law at the time of death of the
Father
father
of
of the
the-
plaintiff. Whether the deeds on the basis of which title have been proved in accordance with law. Yes, these are
So,
the 2 points on which
these are
this
the
appeal
two
has to
points.
be heard.
These are the 2 points. Now,
Yes.
the issue herein is the first issue that is decided as basically issue number 7 in the, by the trial court, learned trial court. My lord takes up the issue number 7, which has been decided by the learned trial court. My lord would find the issue number 7 at
1, 2, 7, 3, 4, 5, 6.
my lord takes
at
up
page
the
88.
But takes up the judgment passed by the Honorable learned trial court,
Issues. my lord,
beginning at page
88.
84. My lord would find the issue number 7 particularly
At page 88.
at page 88.
88.
Page 88 is the list of issues, issue number 7 targets. Issue number 7, my lord would find that page number.
Yes, issue number 7,
like-
whether the date of death furnished by the plaintiff
Yes.
is correct or not.
Yes. But those are the issues that were framed in the suit.
Yes.
And my lord, the principal issue in this suit was regarding the date of death of the original recorded one, from whom the title finally came to the plaintiff by way of registered deeds. My lord would find the issue that has been answered under issue number 7 in page number 90 of the paper book. My lord, that's the judgment of the trial court. But this issue being the most important issue was taken up first for consideration.
Yes.
My lord, if I may read the relevant part.
Yes.
This issue is taken first for discussion because other issues are interlinked with this issue, as a result of which it is taken first. Now, the first question before this court, this learned court arises is that what is the date of death of Taslimuddin Mia? This Taslimuddin Mia was the recorded owner of the entire suit. And from wherein this Taslimuddin Mia sold certain part of the suit land by way of registered deed in favor of the plaintiffs. And subsequently, after his death, his legal heirs being his 3 sons. There was one daughter also who was not entitled, since the Hanafi law was not applicable to the parties here thereof. So these 3 sons, they transferred their father's share in the suit land, in the respective suit Khatia, in favor of the plaintiff. Now, that particular issue regarding the date of death, whether this particular recorded tenant, who was the recorded owner of the original Aris Khatia, whether he would be governed by the Hanafi school of the Hanafi law of inheritance, that is the Muslim law of inheritance,
Or the Daibhaga.
or the Daibhaga school of Hindu law. My lord, in this regard, I would like to refer to a particular judgment. This is the landmark judgment of our Honorable High Court. My lord, I have take your lordship. To the judgment passed in the matter of Anisur Rahman versus Jalira Rahman. My lord, this was. This was decided in reported in year 1981 Calcutta court. My lord, hearing the principal question as regards the applicability of the Hindu law, that is the Daibhaga school of Hindu law, in respect of Kuch Bihari Muslims was unanswered. Why it is applicable and what are the reasons
The
there?
law of inheritance
Yes.
will apply as per the personal law,
Yes.
unless the customs otherwise.
Otherwise,
will.
sorry.
That
Now,
is the thing.
yes. Now, in respect of the district of Kuch Bihar, which was an erstwhile princely state, my lord is well aware of the fact that the erstwhile princely state of Kuch Bihar, it was a separate princely state within the dominion of India even after independence. Subsequently, by virtue of the treaty of merger, it merged with the state of West Bengal and became a district of the state of West Bengal. Now, prior to the assimilation with the state of West Bengal, this
Actually, this district did not have any this Bengali culture and all this thing.
this was a separate coach.
Bengali culture was not there
Yes.
earlier.
It was a separate.
Some other communities used to reside.
Just like the state of Mysore was a
No,
separate.
Purulia was also
Yes,
some
yes.
different district.
Different, it was actually, as per the treaty of accession, it was to be given a separate status of a state, which was not done subsequently. It was converted into a district of the state of Bengal. Now, as per the provisions of law that are applicable to Kuchbihari Muslims specifically, the Muslims who are originally residents of the erstwhile princely state of Kuchbihar, now the district of Kuchbihar, the law which was applicable at that particular point of time has been enunciated in this judgment. If I may refer to the relevant finding of the.
Now, first is the question of law, which law is to apply?
Yes, that is stated in this judgment.
Each
Why it is-
number,
why it is
okay, EIN 1981.
1981 Calcutta 40.
Yes.
Is enunciated in this judgment, and for the first time it has been, this rule has been made absolute that, yes, in respect of Kuchbihari Muslims, the personal law of the Muslim personal law would not be applicable prior to 1st of July 1980. That is the date on which the assimilation of laws of the state of Kuchbihar came into effect. That is the date which was fixed by the state government for incorporating the laws of the
That
state.
means laws were notified to
Yes.
to apply in
By
that state.
Yes, to apply the laws of the state of Kuchbihar, state of West
West
Bengal.
Bengal was made
to
applicable.
apply.
West
And
Bengal as well as India.
No, as well as India, particularly the state of West Bengal, and laws particularly. So the laws which were prevalent in the state of West Bengal were to apply upon the district of Kuchbihar and the inhabitants of that particular district on and from the 1st of July 1980. That is the cutoff date. That is the date that is mentioned in the notification itself. I would refer to the relevant notification and the
So
relevant.
thereafter this judgment.
Thereafter this judgment. Now, if in respect of any person
So state laws were made applicable.
on and from 1st July 1980.
Yes.
Now, before the merger of the state of Kuchbihar happened, originally the residents who were the Mohammedan residents of the erstwhile state of Kuchbihar, they would be governed by the Hindu school of law.
So that means prior to 1980.
Prior to that, yes, prior to 19.
So,
Prior to 1st July 19.
so they were governed by
They
the
were
personal
governed
laws.
by the Hindu school of law.
No, you see, usually Muslims all over India are governed by the personal.
Personal law, that is a Shariat application.
Okay, whatever
By
is
virtue of
there,
the provisions of the-
Hanifi or
I'm
whatever it is.
I'm describing that.
Yes.
Why it happened and why it is so. So before the merger of the princely state of Kuchbihar, what happened is that the entire state was, princely state was governed by a uniform law, that is the law of the in matters of inheritance and succession. However, there was one exception that was under the Mohammedan Inheritance Act. That is the Mohammedan Inheritance Act of 1897. The Mohammedan Inheritance Act of 1897, which came into force on 1st of April 1897, stated specifically that in respect of a Mohammedan subject of Kuchbihar, the state, if he would like to be, if he desired to be governed by the provisions of his personal law, he would have to make a declaration to that effect in the prescribed format.
Before the authority. Before the authority.
Before the authority concerned. That declaration, if not present, that declaration, if found absent in respect of the person who has died, if that person during his lifetime did not make such declaration, or his predecessor in interest did not make such declaration, then he would continue to be
Earlier
governed.
law.
No, governed by the Daivaga school of thought.
That is earlier.
That is the general law for all the inhabitants. So there was, the election was given in respect of the Muslim residents. The way you can choose whether you wish to be governed by the Muslim, your personal law, own personal law, Muslim personal law, or you wish to be governed by the Hindu school of law. Now, persons who exercised that option and made a declaration in the prescribed format before the prescribed authority, were to be governed by the Muslim personnel. Now, in this regard, the principal interest of the party, that is admitted. Is admitted in the cross-examination as well by the defendants, that no such declaration is made by the
No.
Sayyid Taslimuddin Mia was
So that means unless the declaration is made, this is a factual aspect.
yes.
The
Unless the declaration is made,
earlier law will apply.
the earlier law will act. So this is in terms of the Mohammedan inheritance.
So period was mentioned within which the declaration was made by this, this law.
No, the declaration was not made this instant.
No.
Declaration had to be made.
Had to be made within
Prior
what
to
period?
the of the assimilation of state laws act. That is prior to 1st of July 1980. Now, if I may refer to the relevant part, my lord, one takes up the judgment. Which I everybody.
Yes.
My lord takes up number 8 of the judgment, page number,
Yes.
internal page number. This rule is directed against order number 20 dated 28/6/1978 made in the title suit number 21 of 1977 by the Munsif Mathabanga in the district of Kuch Bihar. By the said order, the learned Munsif disposed of applications made by 3 sets of persons claiming to be substituted in place of one Amina Khatun, widow of late Ishakuddin, who, as the plaintiff, brought the said suit. Admittedly, the said Amina Khatun died issueless on February 26, 1978. So that was prior to 1980. In this case also, the death was prior to 1980. There is no dispute between the parties regarding the legal position that if said Amina Khatun at the time of her death were governed by Mohammedan law of inheritance, the present petitioners would have a claim to be substituted in her place as preferential heirs of the said Amina Khatun according to the provisions of Mohammedan law of inheritance. It is the further admitted legal position that if the said Amina Khatun at the time of her death were governed by Dayabhaga school of Hindu law in the matter of succession, the opposite party number 3, Yusufuddin, would have the right to be substituted in place of Amina Khatun. Another set of persons, namely Majitan Nessa and Amina, claim to be substituted as the legal heirs of the said Amina Khatun, but in view of the fact that under the Mohammedan law of inheritance, the present petitioners are the preferential heirs of the said Amina Khatun, and under Dayabhaga school of Hindu law, the opposite party number 3 is the preferential heir. There is no substance in the claim preferred by Majitan Nessa and Amina. Then the next part. In view of what is stated above, the short point that arises for determination in the present rule is whether the plaintiff, Amina Khatun, was governed on February 26, 1978. That is the date of her death. Which was the date of her death by the Mohammedan school of Mohammedan law of inheritance or by the Dayabhaga school of Hindu law. So that was the question, which was the deciding issue in the said judgment passed by the Honorable Court. When the question came up for hearing, the learned lawyer appearing for the petitioners pointed out that even though the fate of this rule depended on the answer to the aforesaid question, the decision of that this court would take in the matter would have far-reaching effect inasmuch as the said question would fall in the determination in quite a good number of cases. Accordingly, on being requested by this court, the learned Advocate General rendered on possible assistance. The Kuch Bihar was previously a princely state of India, came to be merged into and constituted as a district of West Bengal under the States Merger West Bengal Order 1949 with effect from 1 January 1st, 1950. The merger aforesaid, however, did not by itself, this is very important, madam, did not by itself bring about any change in the laws to which the Kuch Bihar was subject before the aforesaid merger. Accordingly, even after the merger was brought about by the said order of 1949, the laws which applied in Kuch Bihar before the aforesaid merger continued in their application even thereafter. This being the legal position, it was found necessary to assimilate the laws which were in force in Kuch Bihar previously to the laws in force in West Bengal. Now comes the assimilation of laws. This necessitated the passing of the Kuch Bihar Assimilation of Laws Act 1950, which was an act of parliament. As the subject of this legislation covers matters contained in both the union and the concurrent list, effectual assimilation of laws could be brought about by simultaneous legislation made by both the central and the state of West Bengal. So there were two separate notifications. There were two separate law.
One is the central law.
One is the central law and another is the state.
Yes.
May I just interrupt? With regard to this settled proposition of law that after the 1st of July 1980, what prevails and before that, there is no dispute in between the
It's
parties.
already admitted.
It is an admitted position, my lord. The only dispute is the date of death of Taslimuddin.
Now, if my learned friend suggests, so I'll come back to that. I'll come to that.
No,
First-
regarding the faith which the parties belong,
Yes.
that there is no dispute. Regarding the
No,
faith,
there is no dispute.
regarding the faith and regarding the law of
Applicable,
inheritance,
law applicable,
law of
applicable,
inheritance,
Yes.
that there is no dispute between
Yes,
the parties.
There is no dispute. And
Okay.
there is also no dispute.
Anyway, but this is
Yes,
also
yes.
the facts of the case.
Yes, yes, and there is also no dispute that Taslimuddin during his lifetime did not opt to be governed by the Mohammedan law. There is
was
also no
declaration.
So he
As such.
continued to be the Daibhaga law.
Yes.
Daibhaga law, Hindu school.
That means if it is Daibhaga school of Hindu law,
Yes.
then the codified law, that is Hindu Succession Act, will
No,
apply.
Hindu Succession Act did not have retrospective application. The Hindu Succession Act was not applicable.
No, but Hindu, what?
Some-
Dayabhaga
Dayabhaga
as
means-
it was, yes.
The uncodified Daibhaga school of India.
Yes.
Because you see, there are two succession. One is survivorship, that is Mitakshara.
Mitakshara.
The
Mitakshara.
other is Daibhaga,
Dayabhaga, yes.
that is succession.
Succession.
So far this succession is concerned,
Yes.
I think after 1956,
Yes.
that is the codified law.
That is
But,
codified.
But at the
was-
time of passing, that law was not in
Not
existence.
in, no, because assimilation of laws happened at a later point of time. That is from 1st of July.
So
1980.
that under the old law.
So it continued under the.
Under the
that's
uncodified
Kuchbehari
law, yes.
It continued under the
So,
Kuchbehari
so
law.
that there is no dispute with
At the time of the
all
Maharaja,
parties, all the
which was-
parties to the suit.
Which was applicable at the time of the Maharaja.
Yes.
And what is in dispute would arise is the succession under the Dayabhaga at that point of time.
That is also admitted already.
No. Admitted, their position has been that and also the learned trial court, my lord, had.
So yes, that is why you see, so
Yes.
far the parties' faith are concerned, all are governed by the old school of.
Old school of Dayabhaga,
law.
and the learned trial court has also held. But the learned trial court has held that under the old Dayabhaga, the girl child did not have any share in the property
Yes.
by way of inheritance.
Yes.
Yes,
And-
whatever under the old Hindu law was there.
Under Mitakshara, my lord will kindly appreciate.
No, you see, the moment you go to Daibhaga law,
Yes.
there is an old Hindu law.
Old Hindu law. That is
Yes.
the law that was
So
applicable
far
to the parties.
Mitakshara is concerned, that is survivorship.
Yes,
Now,
that was
You-
clarified in 2005
this,
that
this
girl child will
succession
have a
act is
property.
there,
Yes.
that is
yes,
the codified law.
Yes.
Prior to the succession act, that is the old Hindu.
Old
Old Hindu law,
Whatever is there,
Whatever
the
is
law is very, if the law is clear, that has
Yes.
to be
That
applied.
is,
that has to be applied.
that is there. Now, since the state laws did not apply to this, to the residents of Kuch Bihar, original residents of Kuch Bihar, prior to the date of coming into force, prior to making it applicable, that is the first day of July 1980. So it continued under the laws that were
That
applicable.
means still today, whoever are governed by the old Hindu law,
No,
till
not
today,
after-
suppose-
not after that particular,
not after,
1st of July 1980.
or thereafter,
Thereafter, all the state laws became applicable.
all the state law.
All the state laws became applicable to the residents, original residents of Kuch Bihar.
And this is the case, this judgment which you are relying is 1978,
This judge.
81.
81 that. Herein it is clarified.
81, it was clarified by the Honorable Court that yes, prior to 1st July 1980, in respect of Muslims of Kuch Bihar, Dayabhaga would apply unless they had opted to be governed by the Mohammedan
Mohammedan personal law.
That was clarified.
But thereafter, the state law,
Thereafter, yes.
And normal course.
Normal course, yes.
All the, as per the
personal law.
personal law of the
Yes.
parties. So this is the only exception in case of the district of Kuch Bihar.
Yes,
So if I may revert back to my original submission.
yes.
So-
That is what I was pointing out, that with
But
regard to,
I have already handed over a copy of the
yes,
assimilation of state laws.
with regard to faith, there is no dispute.
Yes.
The Kuch Bihar assimilation of state laws.
So by virtue of this assimilation of state laws act, the laws which were prevalent in the state of West Bengal were made applicable to the state of, to the district of Kuch Bihar. But that effect came in way later, that is on the 1st of July 1980. It was given effect to by the state government with effect from 1st of July.
So after 30 years.
So if I may refer to here, as a subject of this legislation, this is already referred. That being so, the West Bengal legislature also passed the Kuch Bihar Assimilation of State Laws Act 1950. Both the aforesaid acts, one passed by the central legislature and another by the state legislature, simultaneously came into force on 1st January 1950. But the laws came, that particular law came into force on 1st January 1951. But it was not made applicable to the state of Kuch Bihar, district of Kuch Bihar. Before the aforesaid merger of Kuch Bihar, and before it became as a result of such merger, one of the districts of West Bengal, the Mohammedan subjects of Kuch Bihar state, were being governed by the Hindu law in matters of inheritance. As many Mohammedans desired that they should be governed by the Mohammedan law, an act called the Mohammedan Inheritance Act of 1897 was enacted. This act came into force on 1st April 1897. According to the provisions of the said act, any Mohammedan, that is the subject of election, any Mohammedan subject of Kuch Bihar state desiring to be governed by Mohammedan law would be required to make a declaration in the manner provided in that act that he desired to be governed by Mohammedan law in matters of inheritance. On such a declaration being made in the manner prescribed, the declarant would thenceforth continue to be governed by the
That is
Mohammedan law.
Mohammedan Inheritance Act.
Yes. And would cease to be governed by the Hindu law of inheritance, notwithstanding any custom to the state. So, if such declaration had been made by the person deceased, then in that
Up
case,
to July 1980.
prior to July
1980.
then in his case, the Mohammedan personal law would have been applicable. But no such declaration, admitted position is made. In the present case also, there is no such declaration made under the provisions of the said Mohammedan Inheritance Act. And Amina Khatun, who was a subject of the state of Kuch Bihar or the estate left by her, did not come to be governed by the Mohammedan law of inheritance. So the applicable law was the Hindu law, the Ayodhya School of Hindu. The learned lawyer appearing in support of the rule contended on the strength of the provisions of section 3, subsection 2 of the Kuch Bihar Assimilation of State Laws Act 1950, that all laws which immediately before January 1st, 1951, which was the date on which the act came into force, did not extend to or were not in force in Kuch Bihar, should as from that day extend to, or as the case may be, come into force in Kuch Bihar, and all laws which immediately before that day were in force in Kuch Bihar but not in the rest of West Bengal should on that day cease to be in force except as respects of things done or omitted to be done on that day. If the statute stopped there, the obvious result could have been that the Mohammedan inheritance would stop applying to Mohammedan subjects of Kuch Bihar from January 1, 1951, but that was not the case.
No, you see, here you see, after 1980, there is no dispute.
There is no dispute.
Prior to 1980, that is from 1897,
Yes.
there is a question,
now-
whoever has made declaration.
Now the question comes, that's whether the person who is deceased died prior to 1980 or he died after 1980.
Now another question is, even if it is assumed that 1950, that Daibhaga school of Hindu law will
Yes.
continue.
Yes.
That means it will continue, but after that is repealed,
for-
no, after a new Daibhaga law has come to existence, whether if none of the Hindus are governed by the old law.
No.
You see, after this 1956 Act comes into existence,
The reason being that, if I may explain, my lord, the reason being that is that those laws came into force simultaneously in the state of West Bengal as and when they were
yes,
implemented.
you see, prior to 1956, Hindus as well as limited limited Muslims,
Yes.
they were governed by that
Yes.
old Hindu law.
Yes,
Those who did not opt for that.
yes.
So,
That is with respect to the district of Kuch Bihar. only,
yes,
my
yes, yes. Now, after 1950, that is 1956,
lord. Yes.
if the Hindus are not governed by that old law and they are bound by this law,
No, in respect of the Kuch Bihari Hindus, they continued to be governed by the old Hindu law.
no,
Until-
whether when that law
Until-
itself, when
Yes.
that
because
law
the-
no more is in existence,
Because the state laws were not made effective upon.
it is not a center, that means
What-
parliament laws will also not
No,
apply.
it is not brought into effect. On. it
No,
was
yes, yes, yes. Now
cut
the,
off it.
now the question is, you see, 1956 Act,
Yes.
when it is applicable in all places of India, is it excluded for this
The
particular?
district of, that is particularly the district of.
No, unless there
Yes,
is an
particularly in the
exception.
district of-
No, no, in
the
the act itself,
Yes.
if there is an exception clause that this act will
That
not
is,
apply,
that is specifically the case, and the laws which were prevalent in the state of West Bengal or in the dominion of India, all over India after 1956 or
Yes,
after
whether-
independence.
Because you see, Jammu and Kashmir, probably the Hindu Succession Act was not made to apply,
Yes,
probably.
yes.
And where this customs and conventions prevail,
Yes,
if that is the exception clause.
yes.
it's
But
because-
in this case, there is a special exception to the state of Kuch Bihar, because the state of Kuch Bihar
Because
was,
if there is a special law for any particular local area,
yes,
that succession act
that
cannot,
continues, that
that
law which is-
special law will continue.
that special law will continue unless and until the assimilation of state laws, by virtue of the assimilation of state laws, the state laws are made applicable to it from a particular.
Now the question for dispute is whether this a particular person's
Died before the coming into force of the
1980 or
19, yes, prior to 1980, 1st July 1980, or after that.
so.
So with regard to that, if I may draw your lordship's kind attention to the very fact that is referred, I may pick up the brief notes of my argument itself.
Yes.
Well, it takes up issue number 7, that is the page number 90 of the paper book. Page number 90.
90.
This is the issue. I will learn it. Here colleague is referring to. What is the date of death of Taslimuddin Naqvi?
Yes.
Well, got it.
Yes.
Issue number 7, the first paragraph towards the last part. What is the
No,
date
let
of-
us consider the entire issue.
Yes, what is the date of death?
Entire
of,
observation.
yes, date of death of Taslimuddin Mia.
Yes.
Now, if we read the relevant part, learned advocate, there's a dispute as regards the date of death. What the plaintiff stated in their claim is that the date of death of the present of their predecessor in interest was towards the last part of the Bengali month of Ashwin, 1383 BS.
No, that is learned defendant submitted, plaintiffs are.
There's a dispute regarding the date of death. As
So
contended-
what was the evidence adduced by the
Yes,
party?
well, I'm coming. First, let me put forth the contention that has been raised by the parties concerned. Well, the plaintiffs were of the plaintiffs stated in their claim that the person concerned, that is the deceased person, Taslimuddin Mia, he died towards the last part of the month of Bengali month of Ashwin.
That is, yes, PW1 has stated that Taslimuddin
Page number 2.
Mia, page 90, 90,
Plaint.
place 90.
No, it takes up page number 2 again. There's the plaint itself. I don't have to go and back and forth. Page number 2, paragraph number 4.
Yes, died in the last part of Ashwin.
Ashwin, 1383 BS. Now, if
1975.
1383 BS is taken, now it is 1432 BS. Today, as of 2025, it is 1432.
50 years.
So, 49 years approximately has, so if we subtract 49 years, it would come to
1976.
1976.
Yes.
So, the contention of the plaintiffs was that the person concerned died sometime in the year 1976. Now, your lordship comes back to the issue that has been in page number 90.
Yes.
Learned advocate for the defendants submitted that the plaintiffs are unable to produce any documents relied upon which this court can come to the conclusion about the exact date of death of Taslimuddin. Learned advocate for the defendants submitted that Khatian number 319. This is the LR Khatian which was prepared by the defendants, which we had objected to.
Yes, learned advocate for the defendant submitted that in Khatian number.
319, which is the document of the defendant.
Yes.
It was stated that Taslimuddin Mia died in the year 1975. So their document states that Taslimuddin Mia died in 1975.
That means it is corroborating your case.
Towards my case, because I said it was 1976. They said in their document, it is stated in 1975.
Yes.
Now, this is also not true because later part it would reveal so. The deed being number 2649 dated 25/5/1976, it was clearly stated that Taslimuddin Mia was alive. So the last deed which was executed by the said Taslimuddin Mia was this particular deed, that is deed number 2649.
Okay,
And it
written
was
date.
Executed on 25th of May 1976. So as of 25th of May 1976, he was alive.
Yes.
That is, he himself was alive and he himself transferred the scheduled property. The deed being number 1006, that is the subsequent deed. This is the deed number 1006 dated 17th of April 1979. It was clearly stated that Taslimuddin Mia died. So this was executed by the son of Taslimuddin Mia. By one
Showing
of the
him that as late.
late. Mentioning his father's name as late Taslimuddin Mia. In all the subsequent deeds, this is mentioned as late.
Late.
So this was the first deed which was executed by the son. One
And
of the
showing
son.
him as late.
Showing him as late. So it can very well be presumed that in between 25th of May 1976 and 17th of April 1979, in between this period, this Taslimuddin Mia died at some point of time. So that comes within the cutoff date of 1st of July 1980. It does not cross 1980. What the defendants stated in their cross-examination, in their affidavit and in their written statement was that Taslimuddin Mia died not in the Bengali month of 1383, but in the Bengali month of 1388. It was their contention that he died in the Bengali year of 1388.
That is
Now
in 1981.
That would make it 1981.
So,
Beyond
but so far the deed is concerned, it showed that
it is clear from the
late.
Yes,
Late.
late. And nowhere, not a single document was produced by the defendants in support of their claim that yes, 1981 is the actual date of death of the said Taslimuddin Mia. Not a single document. They did not even produce exhibit a single document. And from their document itself, it was stated, date of death was stated as 1970.
But according to you, that is absurd because
No, that is not possible.
if a subsequent deed is
the
executed,
deed in 1976.
because that deed is not challenged.
Not challenged. So somewhere in between May 1976 and April 1979, this person died. It has also been stated in the claim that Taslimuddin Mia died in the last part of Ashwini and Satyarashi year. Deed number 1445 dated 25th of April 1980 also stated Taslimuddin Mia had died at the time of drafting of the said deed. PW1 had stated that Taslimuddin Mia was alive till 1975-76. So during that period, 75-76, he was alive.
So here is no dispute with regard to that because one deed is executed in 25-76.
Yes.
That cannot be
That
avoided.
is not disputed. That is not objected to even by the defendant during the said deed.
Yes.
PW1 also stated that Taslimuddin Mia was the father of 3 sons and 1 daughter. PW5, namely Abdul Qadir Bashuni. Here comes the part. This is one PW. That is the one of the deed writer. He stated that this Taslimuddin Mia died in 1388.
That is after 1981.
83. They're taking it to 1981. Now, his evidence could not be taken on as sacrosanct.
Is DW or PW?
PW5.
This typewriter, scribe writer.
That is the deed writer.
Deed writer.
That is the deed writer. Now, his evidence could not be taken as sacrosanct. Just the explanation has already been provided there. My lord takes up page number 91 of my paper.
Yes.
If I may give the relevant part. Second paragraph. On the other hand, plaintiffs have stated that the time of death, Taslimuddin Mia, no death certificate or any document of like nature was preserved as he died more than 35 years ago. But from the circumstantial evidence, they are able to succeed and establish the exact date of death of Taslimuddin Mia. They submitted that Taslimuddin Mia died in the last part of Ashwin 1383 years as deed number being 2649, dated 25th of May 1976, clearly stated that Taslimuddin Mia was alive till that date, as he himself transferred the property, but in deed number 1006, dated 17th of April 1979, and deed number 1445, dated 25th of April 1980, clearly stated that that on that date, the said Taslimuddin Mia was dead and was dead before 1979. As it was mentioned in the deed, that that date Taslimuddin Mia had died. The defendant have stated in their WS as well as in their affidavit in chief, DW1, in the scheduled land, the defendants are alleged to be in possession, but they did not produce any khatiyan, perhaps, or in affidavit, in the chief, perhaps in the affidavit in chief of DW1, and they stated that the khatiyan number 319 was missing, On the other hand, plaintiff submitted the Khatyan 319, which was exhibited as Exhibit 2 in the name of the defendant number 1. This document should be produced by the defendant to establish their case, but it did not produce it because in Exhibit 2, it has been clearly written that Taslimuddin Mia died in 1975, which goes against the defendant. All the PW stated that the date of death of Taslimuddin Mia was in the last part of Ashwin 1383 BS except PW5. PW5 stated that the date of death of Taslimuddin Mia is 1388 BS. Now it is to decide whether the admission of the fact stated by the defendant in WS regarding the date of death of Taslimuddin Mia is reliable or not. PW5 now, who is PW5, he is not just the deed writer, he is a relative of the defendant's husband. PW5, Abdul Qadir Bashunia, was a deed writer by profession and he drafted the deed being number 1006 dated 17/4/1971. So he was well aware of the fact at the time of drafting the deed that he is writing the name of the Taslimuddin Mia as late in that particular deed. And deed number 1445 dated 25/4/1980.
Vendor, yes.
In his own hand, that the vendor Abdul Hamid Mia, son of late Taslimuddin Mia, and the deed now being number 1445, vendor Ayub Ali Mia, son of late Taslimuddin Mia. On the other hand, Taslimuddin Mia was the uncle, that is the Pisha Moshai of PW5, Abdul Qadir Mia, as he stated in his deposition. So it is clear before this learned court that he has a clear knowledge that the date of death of Taslimuddin Mia is in the year 1383 years. But in cross-examination, he stated that the date of death of Taslimuddin Mia is 1380 years on the grounds that the defendants are his sisters and nephews. So whatever he stated during cross-examination is not at all reliable by this learned court, and it tantamount to willful suppression of material fact. So in order to save his nephews, that is the defendants, nephews and niece, the deed writer himself converted 1383 VS into 1388.
That is in cross-examination of PW.
PW5. That's the deed writer.
And he was not declared hostile, probably.
He was not declared hostile. After considering the documents, evidences and materials available on record, it appears to me that the date of death of Taslimuddin Mia is in the last part of Ashwin 1383 BS, on the ground that after producing series of deeds and khatyans, particularly being Khatyan number 319, which the defendants ought to have produced, the date of death of Taslimuddin Mia is last part of Ashwin 1383 BS. PW5 is the nephew of Taslimuddin Mia, being a deed writer, written in the deed that the date of death of late Taslimuddin Mia is prior to 1979 AD. But he willfully suppressed this fact and stated in cross-examination that the date of death of Taslimuddin Mia is 1388 BS to save the interest of defendants who are his sisters and nephews. In this way, the plaintiff have discharged their liability and now the burden of proof shifts upon the defendants to establish the exact date of Taslimuddin Mia, because the defendants has taken a specific plea in their paragraph number 10 of the written statement that the date of death of Taslimuddin Mia is first day of Boishakh 1388. As the defendants have taken a specific plea, so they shall have to establish the date of death of Taslimuddin Mia, but they have failed to produce a single document. The WS, as such, the plea taken by the defendant shall be treated as vague and evasive. Principle that the plaintiff have to stand on its own feet shall not be applicable here on the grounds that the plaintiff very successfully discharged the liability of burden of proof, but the defendants failed to do so. Hence, this issue has been decided in favor of it. So, this entire issue regarding the date of death, maybe the exact date of death was not known to either of the parties. The exact date of death could not be ascertained by the learned trial court below. But the
period,
yes,
time
the
of
period.
death.
The period was well ascertained by the deeds itself, by the documents which were laid in evidence, and those documents were never challenged. So now it cannot be said that the Taslimuddin Mia died after that 1980s, sometime after in 1981. That is an entirely vague assumption. Now, as regards, this is the second point. Now, the issue, another issue which has been made applicable in this particular second appeal is whether the property devolved upon the persons concerned in the manner, plaintiffs concerned in the manner that they should have. Now, if I would refer to the brief notes of argument, my lord, for the time being, take up my brief notes of argument. But the crux of the plaintiff's case is that this Taslimuddin Mia, who was the son of late Ajimuddin Sarkar, that is page number 2, paragraph number 3, I believe. He had land comprising RS Khatiyar number 155 by 264. 264. This is the exhibit 1. This is the RS Khatiyar which was marked as exhibit 1.
Yes.
In this RS Khatiyar, he had certain quantum of land. Out of that, he himself transferred 33 decimals in the same in a particular RS plot of the said Khatiyar to the plaintiff number 6. Now, one issue which is there existent in the plaint is that the plaintiff number 6 has been wrongly written as plaintiff number 9 in the plaint itself. My lord would find in numerous paragraphs of this plaint, the plaintiff number 6 has been wrongly written as plaintiff number 9, and the plaintiff number 7 has been wrongly written as plaintiff number 10. That fact has also been discussed in detail by the learned trial court.
And necessary, no, in the cause title, there were,
Was 7, only 7 plaintiffs.
yes,
So
but,
there could not have been a plaintiff number 9 and 10.
but
We are
while
not
this,
seeing any dispute with
but
that.
while discussing the plain
Yes.
amendments,
Yes,
some mistake is committed.
some mistake
Is
is there.
committed.
And that mistake was particularly harped upon by the learned first appellate court. That is the reason why I am referring to that.
But-
The learned first appellate court proceeded to reverse the judgment passed by the learned trial court on the basis of the fact that there is no defendant number 9 and there
There
is
is
no
one
defendant
of
number
the
10.
grounds, but with
Yes,
regard
so
to this typographical error, my lord, we are not taking it up now.
So that was one of the grounds. That is why I am referring. If they are not taking it up,
We are not taking it up. It's evident, my lord, from the pleadings that it is only up to 7.
So
nine,
it
10
cannot
could
be
not-
9 or it
9
cannot
and
be
10
10. But
cannot
that was the
come.
ground which was specifically taken up by the learned first appellate court. When
One of the grounds, yes.
dismissing my this overturning the
Yes.
judgment passed by the learned.
One of the grounds taken there was that.
So
Yes.
this is not an issue here. So now this plaintiffs, not only the Taslimuddin Mia transferred by virtue of registered deed, subsequently by virtue of several other deeds, my lord would find that the plaintiffs were in the plaintiff's favor, particularly the plaintiff number 1, 6, and 7 I am concerned with. Several deeds have been executed by the sons, 3 sons of late Taslimuddin Mia. Now the 3 sons of late Taslimuddin Mia is the, as I stated in the plaint, there are basically 3 sons whose names are Ayub Ali Mia, Abdul Hamid Mia, and Abdul Aziz Mia. So these are the 3 sons. Apart from these 3 sons, the plaintiff, the said Taslimuddin Mia had one daughter, Majitan Nessa Beba. This Majitan Nessa Beba was the
That is
defendant number
paragraph
1.
3 of your written arguments.
Yes, my lord, and paragraph number 4 of the plaintiffs. Now this Majitan Nessa Beba was the daughter. Now, by virtue of the, my lord, as I have already discussed, applicability of the old Hindu law, that is Rayagada School of Hindu Law, to the residents, Muslim residents of the erstwhile princely state of Kuch Bihar, daughters were not at that point of time entitled to a share in the property of their father. Because
No, erstwhile Hindu law, erstwhile Muslim law, you are
erstwhile-
not,
erstwhile, this was Rayagada School of
this
Law,
old Hindu law.
old Hindu law.
Yes, yes, old
So
Hindu
it
law.
was- the daughters were
No,
not
they had limited rights.
limited
Yeah.
right, they were not proportional.
Limited rights,
Yes.
yes, till 1955,
No,
1956.
personally rights in property. So they were that is the reason that they were excluded. So the deeds which had been executed by the sons of the said Taslimuddin Mia, in fact, was never challenged before any learned court by this daughter of the Taslimuddin Mia or by her sons. There is a defendant's hearing. There is a respondent's hearing. Never challenged. Now, the second important issue which I would like to refer on that has been discussed. One of the deeds of the exhibits, various deeds are already marked as exhibits. I'm not going back to that. But I have to take up page number, internal page number 7 of my written notes of argument.
Yes.
But the point number D, C and D basically. C is basically the vital issues, that is the issue number 7, which is with regard to the date of death, and the issue number 2. Issue number 2 and issue number 7 are the important points. Issue number 2 is whether the daughter would be entitled to a share in the property. That was decided in favor of the plaintiff. But in paragraph number
No, vital issue means 7 means with regard to the debt.
death, and issue number 2 is whether the daughter would be entitled.
Yes. So regarding
That
issue
was-
number,
Yes, that is already there in page number 93 of the paper book.
that means not entitled.
Daughter is not entitled.
That is the issue number 2
Issue number two.
in favor of plaintiff.
In favor of the plaintiff.
Yes.
That is the issue number. And it is already stated in that issue that this thing has already been admitted by the learned advocate for the defendant during the hearing of the case, and that is mentioned in the said issue number. There is admission on the part of the defendant. Now, the issue as regards to entitlement of the defendant number 1, that is Martinez has been answered by the in favor of the plaintiff by the learned trial court in page number 93 and page number 97 particularly. On page number, I would find page number 97 of the paper book itself.
97. Yes, 97.
But the second paragraph,
Yes.
the reasonable doubt arises in the mind of the court that who is the in possession of the property. This is just because of the fact that one L.R. Khatian was there in the name of the said defendant, number 1. This is with respect to that. As to who was in possession of the property, submitted the L.R. Khatian being number 319, in which it is clearly stated defendants are in possession of 4.07 acres plot of land out of 8.84 acres of the plot of land which is owned and possessed by late Tasimuddin. It has been decided previously that only the male heirs and successors of late Tasimuddin is legally entitled to inherit the property of their deceased father. Thus, the defendants have no right title interest over the suit land. For the sake of argument, even if it is assumed that the defendant number 1, Maritandesa Deva, was legally entitled to inherit of her deceased father, then she is entitled to get only 2.2 acres of the plot of land, but not as per Khatian number 319, wherein she is in possession of 4.07 acres of plot of land, which is exceeding her own limit of share. She is entitled to. Now, the Khatian which they had prepared themselves in their own name, that shows 4.07 acres out of the total 8.84 acres. That cannot be, even if it is taken for granted that yes, she has a share, then only she can have a share to the extent of 2.07 and not more, 2.2 acres, not more than that. She cannot have 4.07. So that document clearly is a manufactured one, which is evident from that. Exceeding a limit, not and that the document or other document she is holding the property exceeding in that capacity. It is not, and the same document was not provided by the defendants. It was filed by the plaintiffs. So this learned court cannot rely upon the Khatian being number 319 on the ground that the defendants would have paid for an advocate commission to establish the fact that they were in possession of the property. No such advocate commission. Now let us examine the oral evidence of the witness. PW1 has stated that he is in possession of his portion of the suit land. All the PW witnesses, all the petitioners' witnesses in their cross-examination stated that they are in respective possession of their respective. PW1 stated.
No, have you failed to establish position before
No,
the trial court?
No. That
You
was-
see,
that was-
declare that position can be granted under
was
specific-
also established.
if you can establish.
Position was also established by virtue of the evidence.
Yes.
PW1 has stated in his that he is in possession of his portion of the suit land. PW2 also stated that he is in possession of his portion of the suit land. PW3 being independent witness stated that the plaintiffs are in possession of their suit land. PW5 has stated that the property of late Taslimuddin Mia was owned and possessed by his male heirs. So even the PW5, who was the deed writer, who at some point of time made the statement particularly as regards the death of Taslimuddin Mia in favor of the defendants, partly in favor of the defendants, that person also admitted that the land was owned and possessed by his male heirs. Now, my lord, turns the page, that's page number 90. Thus, it was stated the actual fact and subsequently protect the interest of the defendant number 1. It is crystal clear that the defendants have no possession over the suit land, but the plaintiffs are unable to provide any document as to any evidence to Islamic court to establish the fact that there is no one possession of the property mentioned in the schedule A, 4, 5, A to B, except the mere statement made by the So the plaintiffs are entitled to get the relief in their part as paid for. Now, as regards part of the suit property, if I have already
Yes.
conveyed it to your lordship.
Part
but
of
only
the
part of
suit,
the- part
you
of
are
the-
right in your possession.
That is in respect of plaintiff number 1, 6 and 7.
That means declaration was given to this particular plaintiff.
Yes,
And-
except that, except the property which was owned by the defendant numbers 2 to 5.
Yes, so in the suit property, you are able to obtain declaration,
In respect of particular part of the suit property.
particular part of the suit
Yes,
property.
of the
That is declaration and well as
declaration of
injunction.
title interest as well as injunction.
with regard to a particular portion of the suit property.
Yes, now when it comes to the order, that the suit and the same be hereby decreed in part on contest,
Yes.
because in order to call, then is accordingly disposed of on contest, the plaintiffs are hereby declared to be the owner and possessor of the A schedule land property, but except that it has been listed out here at the time of typing, well, it should be evident from the decree, except mentioned in schedule A4, A5, A, so these schedules, not. So these schedules, in respect of these schedules, I did not get the bit. Except the schedules A4, A5, A and B. The defendants are hereby restrained from entering into the schedule land property perpetually except the property mentioned. Except the property mentioned.
No, perpetually,
Except the property mentioned.
yeah.
Injunction also is in respect of excluding those schedule A4.
No, so far this property,
Yes,
that means they are restrained from entering into this portion of the suit property.
they are restrained from entering into
A4, A5
No,
and,
no, no. Except this. Except this.
no,
Well,
no,
I could find the on the.
no, plaintiffs are hereby declared. You
Yes.
get a declaration and an order of injunction.
Yes.
With regard to A4,
Who is not with me, this is the word except has been listed out.
No.
But may take page number 102.
okay,
It would be a clarification. But it takes up page number 102. This is the degree.
yes,
But the middle part
hereby declared the owner and possession.
of
Declared,
the A schedule property with right title interest.
okay, except.
Except the property mentioned in schedule.
So
A
that
four.
amendment of the decree was made,
Malak,
that amendment.
no, this was- there was an amendment petition earlier that was
Okay.
already filed.
And thereafter this decree.
Thereafter this decree was passed.
No, because that portion was left out.
No, this is what except got left out here.
That means-
At the time of preparing.
It will give a different meaning.
Yeah, it will. At the time of preparing this paper, but the decree shows that.
Oh.
it was except
Oh, that except was there only
Yeah,
at the
that-
time of preparing the paper.
paper.
Right.
Because it is reflected in the decree itself. So except the.
So that
schedules-
word except has to be incorporated here.
Yes. Except the schedules A4, A5, A and B, the other schedules were. different.
Okay, proper to position of a scheduled property mentioned except
Except.
position of,
Well, it takes up page number 102 for clarification.
yes, 102. A scheduled right then. Except
Except.
a scheduled property mentioned. Oh, property,
Except the property mentioned in schedules.
okay, that
Yes.
except will be here,
Yes.
except property mentioned in so and so.
So that except got left out at the time of preparing the paper. And my lord, to find at page number 102, the restraining order also in respect of the suit property.
A4, A5,
A4, A5, A and B.
yes.
Except that. The restraining order has been passed in respect of the scheduled property, except the schedule A4, A5, A. So this was the plain case. Now subsequently, my lord, challenging the said decree and judgment, the defendants therein preferred the first appeal before the learned first appellate court. The learned first appellate court, if my lord takes up the order passed by the learned first appellate court, my lord would find the
Page,
order of the first appellate court at page 111. that is the- Page 111 of the paper book. Begins at page 111.
yes.
My lord, then comes down to the relevant part. My lord, there is a discussion on the, which is the heading of the judgment is at page 116.
Yes.
This appeal is arisen from judgment dated 27th of April 2015 passed by the Learned Civil Judge Junior Division Mathabanga, Kuch Bihar in connection with title suit number 2 of 1998, wherein Learned Court below decreed the suit in part and on contest without any cost, but without cost. Now this judgment, if my lord takes up the decision, my lord, that is the ground, ultimately the judgment that was given, my lord, would find it at page number 121. My lord, the second paragraph onwards. On perusal of the plaint, I find that one Taslimuddin Mia was the recorded tenant in respect of 16 annas share in RS Khotian number. It has been mentioned as 155 and 264. It should be 155 oblique 264. But nowhere in the plaint, quantum of share has been mentioned.
Yes,
It
recorded tenant in so and so.
Yes, it further appears that schedule of the plaint has not been properly described. From the plaint, I find that the sons of Taslimuddin Mia have transferred properties to different plaintiffs with a registered sale deed, but those registers have not been marked exhibited in the case. From the plaint, I find that some properties were transferred to plaintiff number 9, but in the post title of the plaint, I find no such whisper that the plaintiff number 9 is one of the plaintiffs in the suit. There is no mentioning in the plaint. I find existence of schedule A7A, schedule A6, A2I, but in the schedule of the plaint, these schedules are found absent. Here, the Learned First Appellate Court missed the fact that the plaint had been amended. There is an amendment petition specifically with respect to that. My lord, take up the amendment petition. My lord.
Amended plaint was filed.
Yes, the amended plaint was not taken into account by the Learned First Appellate Court.
Which page?
My lord, the amended plaint is, this is the amended plaint itself. My lord, the amendment petition I am referring to. My lord would find it at page number 73 of the paper book. This is the amendment application filed by one of the plaintiffs under order 6 rule 7.
Yes.
My lord would go
So, and thereafter the amended plaint was
yes,
filed.
yes.
So it was taken into consideration by the trial court.
So the schedule was modified by virtue of this amendment. The Learned First Appellate Court failed to consider the amended plaint, but actually chose to pass its decision on the original plaint which was filed in the suit. So the amended plaint ought to have been taken into consideration. That contains
So that was taken into consideration by trial court.
trial.
Yes.
this
So
is the
the
amendment.
grounds of this thing allowing the appeal is this
Yes,
was recorded tenant.
yes. And my lord, the another ground that has been mentioned.
No, this plaint was the recorded tenant of 16 anna share. Okay, so and so.
In the said Khatian, he was the 16 anna shareholder.
Yes.
That was Khatian in his name. There is no dispute as regards that.
So some transfer of property has taken place. That was
That
was disclosed.
Those are the deeds that is marked as marked as exhibit.
No, but he stated that not been marked as exhibit.
The deeds have been marked.
Okay.
But find the exhibit list of exhibits. It's already there. Page number 88. Page number 88 of the paper book, 88 and 89. These are the exhibits marked. Defendants did not submit any document, so there were no exhibits on the part of the defendant. Even the signatures were marked as exhibits. Yes. Page number 88 and 89 in the paper book.
Now regarding the points of law which was formulated, yes, govern. So it is not a dispute that the plaintiffs and defend, no, these question comes into consideration. You see, when the date is
Yes.
established.
Yes, the date of.
This question depends upon the establishing of the date of
Date
death.
of, now the date of death has already been established to be somewhere between that deed which was executed, last deed which was executed by Taslimuddin Mia, that is in the year 1976, May 1976. And the
No,
first
the original plaintiffs have claimed their rights by virtue of transfer.
transfer, yes.
Yes. Now the
Transfer.
question is, the deeds on the basis of which plaintiffs have claimed their have been proved. That means
Yes,
the very documents were proved on.
Yes, those documents were already exhibited, not objected to by the defendants.
So this is with regard to proposition 2.
Yes, proposition 2.
The number 1 is whether is the defendants
Date
were
of death.
governed by Mohammedan law in a defendants. Yes, defendants, not defendants. You see the
Yes, defendants means the contesting defendants.
contesting defendants and the success,
The predecessor.
yes,
Yes.
the assigner.
Yes, Taslimuddin Mia, the
Yes.
original recorded owner.
Yes, yes, assigner,
Yes, assigned.
who assigned this rights, that is
Yes.
the vendor of the suit property.
Yes, basically the person who has died, this is Taslimuddin Mia.
But it is not that he sold, probably his
No,
heirs sold.
he made one deed.
No,
Prior
this
to
is-
his death, one deed was executed by him in the month of May 1976.
Now you see, these present plaintiffs are the purchaser of the suit property
Suit
from the
property.
original.
Sayyid Taslimuddin Mia as well as from his sons.
So the question is whether the original owner and the, yes, original owner
Original owner
and
and his sons
assignors and their sons
and successors.
were governed by Mohammedan law or Hindu law.
Was
Or
governed by-
Daibhaga school of
So
law.
the Ayurveda school of Hindu law, the
If
daughter.
Daibhaga school of Hindu law prevails, then
the
one
daughter
thing.
will not be entitled, in that case, the male.
And the other question is whether the deeds on the basis of which, you see, that is proved, that is two things, but the third one is not there, whether the trial court rightly came into the conclusion in holding that this person died prior to 1980, that,
That is already discussed in issue number 7 by the Lanet trial court, because. it
no,
is-
whether the appellate court reversed that finding.
No, appellate court
Appellate court did not reverse that finding.
As regards the date of death. Appellate court
So anyway, on these 2 points, the,
only appellate court only passed its judgment with regard to the specific 2 points. One regarding the there was no existence of plaintiff number 9, and another fact being that this particular LR Khatian, since this particular LR Khatian 319 was there, it means that they have right in the property. Now, your lordship knows very well that in respect of an LR Khatian, the LR Khatian is a revenue record. A revenue record cannot grant any title, right title interest in favor of it. It is only a document for the purpose of assessment of land revenue. Now, holding that, the takes up for page number 121, the second paragraph, at page number 121. This is the observation made by the Lanet First Appellate Court. For the plaintiffs have admitted that name of the defendants have been recorded in LR Khatian number 319, obviously. So this was produced by us, but plaintiffs did not pray for any consequential need to that effect, as plaintiffs did not pray consequential need. So this instance should be read by section 34 of specific. How can it be? Section 34, I have already paid for declaration of my right title and interest. Now the Lanet First Appellate Court says, since I did not pray for declaring the Said Khatian, recording in the Said Khatian as erroneous or invalid, I am not entitled to a decree. That cannot be, because the provisions, your lordship is well aware of the provisions of the West Bengal Land Reforms Act.
yes,
regarding
whether court is empowered,
Well, obviously, the
empowered to adjudicate this issue.
civil
or not.
court is not empowered to adjudicate on a record of rights.
Anyway, so you have completed today?
Yes, I'll submit certain judgments regarding section 34 of the specific.
So let your learned friend start on the next
I'll
day.
just hand over the copy.
Yes, otherwise it
With a copy to my.
otherwise it cannot be concluded.
Yes.
And my lord, I will be also referring. to
Monday.
Yes,
continue.
certain documents of the trial court record,
Yes, yes.
because
LCR.
specifically, okay, because some of the documents are not part of the paper book. So I will be referring to this. Specifically, my lord, the defendant's evidence, my lord, DW1.
Yes, you give it. If it is not part of the record, you see,
It is there.
the matter cannot be taken up also. The arguments, even If the argument is concluded also, it will be a futile
It is
exercise.
not part. আছে এখানে DW
You
one
please
is-
clarify.
Very well, I'll just speak with.
Monday you start.
Yes, yes.
Yes, record an order. Learned advocate for the appellant submits
এই DW আছে আমি খুঁজে
আহ,
পাইনি। দেখো তো।
and has concluded his submissions. Fix 22/12/2025 for submission of learned advocate for the respondents. Let this matter appear on 22/12/2025 at 3 p.m.
Yes. Yes, madam. 3
3
p.m.
p.m. to
Yes, so that my lord can take up some other matters also. before. Yes.
some few matters have to be taken.
Yes, yes.
Because we also don't know on which day it will be 3:30 or
Yes.
not. That uncertainty is always there.
Yes, my lord.
Anyway, we shall let us see if we can
Fine.
conclude it.
I'll try to conclude it on that day only.
Thereafter, he will reply and you also file your written notes.
Yes, I will file my return. Grateful, my lord.
Grateful, man.
এইটা কাগজটা একটু দিলে।
রেকর্ড একবার দেখে নেবে এখন। না, my lord কে উঠতে দাও।
এই দুটো জাজমেন্ট ভেতরে পেপার বুকের ভেতরে কাগজ ইয়েস Yes. CO matter for
The defendant in the title suit prepared a petition for default of BW. He wanted to do some documents over.
no is it appearing for the first time? Okay, is there any caveat? No, if there is a caveat, you have to serve the caveator and come.
Will serve the notice. the meantime.
No, question, if there is a caveat, then only you have to serve. You check, okay, you give the slip, it will appear on the next day, Monday, but you see if there is any caveat, obtain a caveat, no caveat certificate. Yes. Yes. Item 20? No, other side has appeared. No, it's a contested application.
I also filed an application for action kindly.
Yes, record an order. Learned advocate for the petitioner is present. No time today. On the grounds of exigency, the interim order granted earlier stands extended for a period of 4 weeks or till further orders, whichever is earlier. Yes, it will remain in the list. Let this matter appear on 23/12/2025. You intimate the other side if somebody has appeared. Anyway, if it is not taken up, it will be, I've already extended it for 4 weeks.